If you believe the American system exists to restrain power before it crosses the line, then what just happened should stop you in your tracks. This wasn't a legal squabble, and it wasn't a political signal. It was the constitutional system itself stepping in, with complete clarity and unanimous force, declaring that one of its former commanders no longer qualifies for protection. For the first time in U.S. history, the Supreme Court acted decisively. It closed ranks and stripped a former president of every remaining legal shield. At 4:47 p.m. yesterday, Donald Trump's legal team went completely silent. Not a strategic silence, not a coordinated pause, the kind of silence that follows an earth-shattering impact. Phones stopped ringing, no statements, no leaks, no trial balloons. According to sources familiar with the moment, it was the sound of a legal fortress crumbling in real time. Here's where the timing becomes crucial. 18 hours earlier, while most of the nation slept, the Supreme Court issued a ruling that was neither incremental nor cautious and not reversible. In one sweeping decision, it dismantled every legal shield Trump had built over 3 years. Presidential immunity, executive privilege, delay tactics spanning 4 criminal prosecutions and dozens of civil cases. Gone. Let me say that again for emphasis. Gone. In 247 years of constitutional history, no former president had ever faced this. Not Nixon, not Clinton, not anyone. This wasn't a trimming of authority. This was a complete removal of cover. And here's the part that should freeze Washington. The 3 justices personally appointed by Trump, meant to be his firewall, all voted against him. All 3. The final ruling was 9-0. No concurrences, no dissents, no hedging language left for reinterpretation. This is unprecedented. Publicly, the court released 63 pages of dense, methodical reasoning crafted to withstand decades of scrutiny. But beneath the surface lies a sealed appendix, 47 classified pages restricted to the attorneys of record and the justices themselves. According to sources, a single paragraph in that appendix carries consequences far beyond legal theory. Immediate criminal referrals, multiple jurisdictions, and the potential activation of 3 separate grand juries from a single block of evidence. Here's where the narrative shifts from a legal event to an institutional reckoning. Early drafts tell a different story. Justice Clarence Thomas had prepared a 32-page dissent defending absolute presidential immunity. Justice Samuel Alito aligned with him. Justice Brett Kavanaugh leaned the same way. That alignment made sense. It followed decades of jurisprudential caution and ideological expectation. Then, January 8th happened. A classified briefing from the Department of Justice 2 hours behind closed doors. No transcripts. The subject wasn't politics. It was national security implications arising from Trump's cases. What happened in that room remains secret, but the institutional reaction is visible. Thomas withdrew his dissent. Alito never filed his concurrence. Kavanaugh reversed course entirely. The opinion locked into unanimity. Pause for a moment. The court's most conservative members did not shift due to cable news pressure or public opinion. Whatever they were shown outweighed ideology, political loyalty, and long-held caution. The institutional calculus flipped. Protecting Trump was deemed more dangerous than exposing him. That is a threshold few would have imagined. And it didn't stop there. Buried deep in the ruling is a procedural trigger most headlines missed. Trump has 14 days to respond formally. That clock is now running. Constitutional experts warn that responding creates a trap. Any defense risks self-incrimination across multiple cases, while silence carries its own legal consequences. This is not rhetorical, it's structural. This moment is historic. The court didn't just resolve a dispute. It asserted jurisdiction over presidential conduct in a way that permanently alters the legal landscape for future executives. The ruling was written not just for Trump, but to remove a category of defense from the presidential toolkit entirely. The justices knew exactly who they were ruling against. They knew the political fallout. They knew the pressure. And they moved anyway. Washington is circling the question, not yet voiced aloud. What convinced the court that the institutional risk of inaction outweighed the risk of confrontation? This collapse didn't happen overnight. It tightened slowly, methodically, until Trump's team found there was no slack left to pull. Mistake 1. Overplaying presidential immunity. In February 2024, the D.C. Court of Appeals rejected Trump's claim of absolute immunity. Narrow, precise, and explicit. Trump's team could have pivoted, absorbed the loss, narrowed exposure, protected time. They did none of that. Instead, they filed an emergency application to the Supreme Court, expecting delay, hearings, maybe a sympathetic conservative ruling. What they got instead? Silence. 11 months of silence. No briefing schedule, no oral arguments, no leaks. Silence misread as indecision. It was alignment. Mistake 2, assuming prosecutors had revealed their best witnesses. They hadn't. The decisive witness, hidden in plain sight, known only as Executive 1 Assistant, kept minute-by-minute handwritten notes of the White House panic on January 6th. 917 pages of instructions, meetings, reactions, evidence that doesn't argue, it accumulates. This turned the legal fight from interpretation into exposure. Mistake 3, underestimating Georgia. While federal cases dominated attention, Fulton County was building a racketeering case under state law. Same timeline, same witnesses. The Supreme Court's ruling explicitly applies to state proceedings. That erased every Georgia defense instantly. Trial date, April 15th. No presidential pardon can override state convictions. Mistake 4, ignoring civil cases. Trump's legal team prioritized criminal matters, leaving $83 million in defamation and $454 million in New York financial fraud judgments pending. Those arguments, based on immunity, evaporated with the ruling. Asset seizure can now begin within 30 days. Pressure is coming from all directions. Exits? Trump's team tried 3: emergency stay, political question doctrine, and challenging Supreme Court jurisdiction. Each failed. One seasoned conservative attorney refused to sign the jurisdiction challenge. The court made it clear, no one in the U.S., regardless of office held, is above criminal law, including presidents. The evidentiary standard, reckless disregard. Prosecutors need not prove Trump knew his actions were illegal, only that he ignored 17 clear written warnings from White House counsel Pat Cipollone. Executive privilege. Gone for criminal activity. Privileged documents must be submitted for review. If they reveal criminal conduct, they become evidence. This is not one defendant. It's a synchronized system, criminal, civil, federal, state, each reinforcing the other. Timing matters. February 7th, document production deadline. February 15th, Georgia hearing recalibrates trial posture. March 4, federal election interference case resumes. March 15th, New York civil judgment becomes enforceable. April 1st, Florida classified documents case moves forward. April 15th, Georgia RICO trial begins. Evidence and rulings now migrate between cases. No firewalls remain. Criminal cases can't be settled. State convictions can't be erased. Escape valves are gone. The system executes its timetable, not the defendant. 3 potential futures emerge. Accountability holds, trials proceed, evidence tested, verdicts rendered. Political strain exists short-term, but institutional credibility survives. Accountability collapses, pressure overwhelms process, cases unravel, precedent favors power, system fractures, courts diverge, legitimacy erodes, law becomes a contested weapon. Next signals to watch: statements from former White House counsel, timing of Mike Pence's testimony, silence from Republican senators once defending Trump. This isn't prediction. It's recognizing a phase change. Institutions are aligned. The calendar advances. Pressure compounds. And now the most consequential decision may rest with Trump: operate inside a system that stripped his protections or confront it directly. The question isn't just what happens to him. It's what happens to the constitutional order that must now enforce its limits or admit it cannot.